SJC-11725, Commonwealth v. Johnny Colondres.
Good morning, Mr. Schnipper. Please proceed.
Good morning, Chief Justice, and may it please the Court, I'm Merritt Schnipper for Johnny Colondres. The need to ensure that police remain within the scope of the search and seizure authority given to them by a magistrate justifies suppressing the evidence taken from the defendant's apartment in this case. The detective in this case executed the warrant without waiting to see whether Carlos would deliver the cocaine to the south end of Springfield, only hours after he asked for and received a warrant that included that express limitation. The only reasonable inference from these facts is that the detective was aware of the limitation the magistrate had placed on his authority and consciously chose to disregard it. Because this case deals with intentional police conduct, the deterrent effect of the exclusionary rule and suppression of the evidence will be at its maximum.
That's where I see your point, but Frank's also involves intentional misconduct, that is a knowing false statement. But all we do there is we sever the false statement and see whether there is probable cause without it.
That's right, and I think it's interesting to distinguish this case from Frank's because what you're dealing with there is the impact of the, and I'm not contending that there's fraudulent conduct here as much as intentional violation of an order, but in Frank's what you do, because the court was presented for the probable cause determination with a set of facts, a subset of which were falsely stated or fraudulently obtained, then you're still going to have a warrant that issues upon probable cause if you sever the false statements, take them out, and look at the sort of denuded affidavit. But what you've got here is nothing that was done wrong in the presentation to the magistrate, so that if you were to excise the triggering event section and just say, well, without that section, we still have an affidavit that creates probable cause to search this apartment, we're still left with the situation where the warrant as given to the officer contains the limitation, contains his triggering event affirmation within the affidavit upon which it was issued, and then he then goes out and disobeys that condition. So unlike a Frank situation, and unlike an excising situation like the De Jesus case, we're not faced with a situation where we can cure the harm by simply removing the request, because what the harm here is not the probable cause didn't exist for the warrant to issue, although I contend that it didn't without the triggering event, but even if it did, we're still left with a police violation of a magistrate's order, and the judicial control over the determination of when police can search and seize has still been violated unless suppression is the remedy.
Well, except, I mean, if you play that out, technically, the warrant, which would be the magistrate's order, doesn't include it.
That's right, but in both Commonwealth v. Soares and in Commonwealth v. Gauthier, this court specifically said that the triggering event listed and detailed in the warrant defines the scope of the authority to search and seize. So unless you've got a situation where we're going to take a warrant that's supposed to be present at the point of the search, both to guide the police power and to inform the subject of the search of the limitations of those power, unless those limitations are only going to be decided after the fact by judicial review, then we're going to have a serious particularity requirement with these warrants, because at the time of the search, neither the officer nor the subject of the search is going to be able to effectively say what the limitations are. And I think it's very important to realize that in this specific context of an anticipatory request, the police are not only saying to the magistrate, please rely on the facts that we're giving you, but they're also saying, please rely on the assurances that there will be a temporal limitation and certain events that have to occur that have not yet occurred that are going to happen before our right to intrude on this person's home will be triggered. So if you're going to simply excise it and say, well, he never needed to make that representation, so the fact that he did should be discounted in the suppression analysis, what you're left with then is saying, well, in the future you can make these representations, and if it turns out after the fact they weren't necessary, then the fact that you violated them is not going to have any impact on the prosecution.
But let's look at this practically. I mean, first of all, in my view, there was no need for an anticipatory warrant here, but because ordinarily that means there's no probable cause until a certain very specified event happens. My view is that there's probable cause here. anyway. But your point about, well, you know, it's got to be complied with strictly or there will be police misconduct. Isn't the real issue here whether or not, is it Mr., who's the carrier of this?
Well, there's
Not your
Carlos
client. Whether or
Colondres is
not
the nephew.
Issue is whether or not Carlos was going to leave that apartment with cocaine, to deliver it to someone else. Not the fact of the delivery is almost irrelevant, because all that means is, well, if there's a delivery, then we can grab it and make sure it's cocaine. But in fact, he walks out of the house, gets in his car. They have probable cause to arrest him. They've had probable cause to arrest him for quite a while.
Arrest him for a month or two.
And he has cocaine coming out of the apartment to deliver it to someone.
Well,
Is the delivery the key thing, or is it the fact that he leaves the apartment when the confidential informant says he will be leaving it with cocaine?
Well, there's actually 3 points that you bring up there. First is as framed by the requesting officer the delivery of the thing? Yes, I don't think there's any possible way to read that affidavit and say that the officer doesn't say it should be triggered by the delivery. The second is that, as the Commonwealth has correctly pointed out, we don't know the identity of the alleged recipient of this transaction.
And it doesn't matter, really.
Well, it does matter, and here's why. Because the informant in this case has not been able and not provided any basis to believe that he or she can predict Carlos's movements. And in fact, the entirety of the affidavit, as laid out by Detective Wadlager, says this drug dealer, Carlos, who is not the defendant here, uses these methods that I recognize from my training and experience as a way to shield his customers from the facts of where he picks up
And that
his
shield
drugs.
has been broken through
But
this
it hasn't been
investigation.
broken by information provided by the informant.
Of course it has.
Well,
I've called
purchases-
him, he's told me to go to this place, he's told me he has to go pick up the cocaine or the heroin, whichever it was. They follow him, he goes into an apartment for a few minutes, comes out, goes to the place, drops the drugs off. Of course he has demonstrated that there's probable cause to believe that this place that he visits just before he does a drug deal is a place where the
let's look
drugs
at the
are.
nexus question for a second in terms of probable cause. What we have is so we don't have any information from the informant about this apartment. What we have is
Well, let's assume he's never been in it.
right. I think it's pretty fair.
But the police have followed this person to that apartment just before he makes a drug deal. When he says, for instance, I've got to go pick up the drugs, I'll meet you at place X.
Right, so
Goes to
here's-
that apartment, spends just a couple of minutes there, comes out, goes and delivers drugs. So he's been followed. So this pattern has been established.
Well, here's what's been established. 3 trips to that apartment, one which preceded nothing other than a return to his own home and no illegal activity, one which preceded a controlled purchase of heroin 3.5 weeks before, and one which preceded a controlled purchase of cocaine. And I would mention that if you look at the affidavit at Record Appendix 18, during the single controlled purchase of cocaine, that again does not involve any sight into the apartment, but a stop by it, Carlos is not followed from his home to the apartment. He's simply observed arriving at the apartment. So we don't know. And I'm not saying that these don't create suspicions. They do. But this is why an experienced police officer said, I need this transaction. I need confirmation of this pattern.
What does he need? He needs confirmation that the individual has the drugs after visiting the apartment.
To create probable cause.
Well, no, not to create. Well, that's the anticipatory piece here. My view is that he doesn't need that to create probable cause. But the point is, if this is part of the anticipatory trigger, it's leaving the apartment to deliver drugs with drugs, which is really the trigger.
Right, but what you're doing, Justice Cordy, is you're saying let's rewrite the warrant affidavit for what it should have been in order to create probable cause without requiring the condition that the police asked for and then violated. So even if you're correct.
Why is the delivery a triggering event here as opposed to leaving the apartment with drugs to make the delivery?
Are you saying if they had written it that way, would that have created probable cause? Or are you saying why did the police? Because the reason
Why do you think the delivery is critical to the triggering event?
That the confidential informant predicted was the delivery of cocaine. So in other words, what we have
I
is
thought he predicted that he would go to the Oakview address or whatever it's
Yes,
called.
he did.
There's no reasonable way to read this affidavit and believe that the magistrate would have believed that the informant told Detective Wadlager that Carlos was going to go to this address to pick up that cocaine, because Detective Wadlager specifically affirms again and again that this Carlos is hiding the stash house of his drugs
He's been
from his
trying to do-
customers.
he's been trying to do that, yes.
Yes, and the only way that the police know about it is because they followed him. So fine, legitimate police work following him. But to read that in a
Okay, well,
common sense
let me just read
form-
the affidavit.
Please do.
The information came from the aforementioned CS. The CS stated to me that Colondres would be leaving 14 Berkeley Street, going to 250 Oak Grove to retrieve the cocaine and then make the delivery.
You have read that correctly, but there is no plausible way to believe, when you look at this affidavit in the common sense reading, which is as a whole, which is what this court has said over and over again, that to believe that CS actually had the base of knowledge to make that prediction
He
about
has had a
stopping.
tremendous amount of knowledge. He was doing undercover work for 2 months.
And what he was
providing
doing was-
accurate information and making
He was
controlled
providing
buys.
information about a phone number of a drug dealer and the fact that he could purchase drugs from the dealer. But even, let's just accept, for purposes of argument, that you are 100% correct and this delivery was not needed. We are still left with the core question here, which is what do we do when a police officer expressly requests a limiting condition in an anticipatory affidavit and then 2 hours later violates that actual condition?
But on that point, wouldn't it be a much different situation if the going into the apartment had preceded the arrest of Carlos?
I'm sorry, I don't understand.
Well, in other words, they didn't go into the apartment for which the warrant.
Oh, I see. Yeah, they waited until Carlos left the
Yes.
apartment to execute
So
the warrant.
my point is, yes, technically they didn't follow all the details that had been in the anticipatory language. But, I mean, this is Justice Corey's point. The gist of the anticipatory part was seeing if the drugs were going to come after the trip to is it Oakview? Do I have that?
I think
something.
it's Oak Grove or,
Oak, whatever.
it's a deciduous street.
Okay, I'll just call it Pine. From Pine Street, from that address, leaving that address to go to be delivered somewhere. So they got the gist of the anticipatory part. I mean, this is the argument the Commonwealth makes, but.
Sure.
So if you're looking at, if the problem here isn't a Frank's problem, as you've said, it's about not obeying the warrant, what they've said to they're not following what they've promised the magistrate. But they're coming pretty darn close. And does that count?
I don't think it does, and I think there are two reasons that it doesn't. I think first, what police were looking for by describing the anticipatory section the way they did is what they were looking for is to put together the entire sort of pattern that they had felt that they had identified in bits and pieces. So they were saying, at this point, we've received a prediction of a delivery of cocaine to the South End. What we want to see is whether the entire pattern of this drug dealing that we believe is going on is going to play out the way we believe it will, and if it plays out the way we believe it will, and the way we believe it will play out is by him going from his home, stopping at the apartment, going to the third-party location in the South End, delivering the cocaine, then we will have confirmed the suspicions that we have from our investigation. So I think that's why it was structured that way. And the second important thing to realize is that you say they got most of the way there, but a case that I think is really illustrative on this type of the prejudice and the violation of Article 14 specifically here is Commonwealth v. Rutkowski, where the court discussed the idea that, this was a warrant to search for stolen handguns and antique jewelry. And the materials were listed out in detail in the supporting affidavit, but the affidavit didn't accompany the search. It wasn't presented to the person whose home was searched. And it's not a question, it's not the fact that they didn't particularly describe the objects of their search. It's that their non-compliance with the actual requirements of the entire search and seizure protocol prejudiced the defendant because there was nothing present to limit the scope of the search and to inform the defendant of that scope. Now, here what we've got is an order that, without doubt, contains the delivery of cocaine as part of its condition. Now, we can say they got pretty close, and we can just kind of say like an almost as close enough type of analysis for Article 14 of the Fourth Amendment. But the point here is that if police are allowed to take an order, and again, this is a limited type of warrant that just limits their discretion to execute in a way that most warrants don't. If they're allowed to step outside that until they figure out just how many limitations they can violate, they're going to keep doing it. I mean, this is really why it's an exclusionary rule kind of policy rationale issue, because it's not about probable cause. It's about judicial control over the warrant issuance process.
If I can ask you a practical question, okay? Imagine a police officer who says, well, I think I have probable cause, but I know it's a bit stale. I don't know whether or not that darn SJC will support me on this. So I could go and maybe get a warrant, but I'd be worried about it. So what I'm going to do is set up this situation which will eliminate the staleness and make it rock solid. And you go and get anticipatory warrant, and it turns out that the circumstances, for whatever reason, are a little bit different. What are you supposed to do?
When you say the circumstances are a little bit different, because one thing I sort of take serious dispute with the Commonwealth saying here is that things didn't pan out exactly the way the government predicted, because the reason they didn't pan out is because the government didn't allow them to play out in the exact way that the government had asked to be allowed them to play out. So in order to say it didn't work, you know, because lightning struck and the telephone fell over and the guy couldn't drive down the street he was supposed to go down to, well, you know, we might have something there. But here what we have is the exact same officer who said, please put this limitation in my warrant. And then 2 hours later, he's kicking down the door without letting the limitation occur. So, you know, we might have a different situation where it was 2 weeks later and a different, or, you know, 5 days later and a different officer is executing. Maybe that officer didn't really understand the way, but in here where we're really talking about clear direction that is coming straight from the requesting officer, there's not a lot of that play that you're talking about. So, I mean, I think you could have a different factual scenario where things are out of police control, and that you can get to a point where you might be talking about there's really nothing they could have done to comply with the law better than they did here. But in this case, it's clearly it was very easy for them to have complied with the law.
All right, thank you.
Thank you very much.
Good morning. May it please the court, Assistant District Attorney Bethany Lynch representing the Commonwealth. In this case, an anticipatory warrant anticipates that it contemplates a lack of probable cause unless or until an event occurs. And in this case, I would argue that the point or the delivery was not the event. The delivery was not the event that created the probable cause which allowed this warrant to be executed.
Even if that's right, how do you get to the point about judicial control over warrants, particularly anticipatory warrants, where whether or not the police were right in asking for one, whether or not they were right in thinking, well, that we don't really need that last part, whether or not they were right or wrong about that. The fact is they requested this. And for all we have to assume, the magistrate relied on it. Mm-hmm. And then they don't do it. Even though, as I think you're not going to argue otherwise, compliance would have been very simple.
Compliance would have been simple, but it also would have involved a risk that they could have lost the evidence.
But wouldn't they have known that when they asked for the
They may have, yes. They may have known that.
There's nothing really that's changed from the time that they asked for the warrant and got it.
No.
And executed it.
No.
And for me, it seems like there is an issue relating to you get a warrant on particular terms and then you don't comply with it.
Well, I would argue that that they substantially complied, and they complied with the elements that led to probable cause.
They decide, notwithstanding no change in facts, they decide.
They decided in their
discretion. The police will be able to decide, not the magistrate. The police get to decide what warrants, what parts of the warrant they'll comply with.
No, I would not agree that the police can decide when to execute the warrant regardless of what the magistrate said. In this case, the magistrate, assuming that they accepted all the language within the affidavit, the magistrate limited the execution of the warrant to a series of events that would create probable cause. And in the event that the police failed to comply with one of the events, upon review, this court can determine whether or not that event was necessary for the creation of probable cause and excise it out if they find that that part of the warrant was not necessary or was not complied with.
Doesn't that get to a different issue than what I'm addressing?
Well, I was addressing, I may be misconstruing your question, but as I was construing it, if the police made a mistake and there was an error in the execution of this warrant, then what would be done would be exactly what has been done here, and the warrant would be challenged. And then a magistrate or a court or this court would then determine whether or not the error by the police officer, if there was one, was sufficient to undermine and undercut the probable cause that allowed the warrant to be issued in the first place.
But which is the Frank's approach to life. Exactly. But I think what Justice Lenk is saying, and it's Mr. Schnipper's argument as well, is that doesn't the paradigm change when the issue is the authority of the magistrate to set the terms of the warrant, and indeed as requested by the police, and then the police, don't they have to then do it? So it isn't just, well, you're going to be penalized if you don't do enough of this to get probable cause, but you still arguably flaunted the directive of the magistrate.
Well, I would not agree that you were flaunting the direction of the magistrate. In this case, the magistrate directed that, adopting the language of the officer, that when a series of events occurred, then that would trigger probable cause.
Right.
And again,
Well,
that's
that
assuming
would
that
trigger
there was
your ability to go into the house.
Right. That's assuming that it did not already exist, which again the Commonwealth disagrees with, but that's a separate issue. Assuming that there was insufficient probable cause in the underlying warrant without the triggering events, there was a series of events, and admittedly, the Commonwealth has never argued that the officer complied with every single one of the triggers. But I think that in a situation like this, we don't have the information, as there was no evidentiary hearing, so we don't know what the officer's justification was. It was done on the four corners of the affidavit, and then very limited discussion through argument as to the events that were uncontested. And the events were that the CS told the officer, as we have discussed, that Carlos would leave his house, which he did, that he would drive to the apartment, enter the apartment for a short time, which he did, exit with cocaine, which he did. But until the police stopped him at that point, where it was a controlled situation, they didn't know that. So they made a determination in their discretion. Whether that was incorrect, I leave that to you. I would agree that they did not comply with each and every element that was listed on the face of the warrant. But the fact that they failed to comply with the least, I would argue the least important of those, because at that point, the probable cause had been established if it did not occur before. The strictly observing Carlos leave that apartment and drive towards the south end, I mean, was he required to actually give the drugs to a third person? If the police didn't find that third person, then we have less to work with than we do if it was stopped in the controlled situation. So the only element or the only event in the chain that the officers did not, even if you phrase it as chose not to comply with, was the only element that did not any longer link the drugs to the apartment. And this was an experienced officer, and officers do have discretion in determining how search warrants are executed. I do agree that there was an element that was listed that the officer did not comply with. In a situation like that, I think the primary question for a reviewing court to look at is whether or not the defendant's Fourth Amendment, Article 14 rights were violated and a warrant was executed without probable cause. Because in this case, I would argue that there was probable cause, possibly without the anticipatory triggers. Even if that did not exist, the triggers that were satisfied created probable cause.
Let me ask you a question. Instead of having a case like this where arguably some of the triggers were not complied with, but let's just say everything that made it sort of anticipatory, which was part of the warrant issued. Suppose the police had not bothered with any of that, and your argument would be yes, but they still had probable cause. But then it's just clearly in contravention of the aspect of the warrant that made it anticipatory. What then?
In that case, I would suggest that the court would look at the warrant, and if there was underlying probable cause and the anticipatory warrant portion request can be excised out and probable cause remains, then it's a Frank's, because
So then
it would be
it's just
a
not
similar-
relevant at all that they've asked for an anticipatory warrant, the magistrate has relied upon those representation in issuing the warrant, whether or not the magistrate himself could have, or herself could have been wrong about whether or not more was needed, but nonetheless issued the warrant on the basis of the affidavit that contained this anticipatory portion. And you're saying that in the exercise of police discretion, they can not fulfill those conditions, and we would still do just a Frank's analysis to see whether or not there was probable cause.
Yes, I would say that if probable cause existed and the police took the extra step upon receipt of further information and
No, I'm saying
made
nothing's
it
changed.
anticipatory.
Nothing's changed. Just let's leave it that way. There's nothing changed. They just didn't do.
No, I know, but they chose to request an anticipatory warrant where they
Didn't need
didn't
one.
need one.
Didn't need one, but then.
They chose to do that, but then failed to comply for whatever reason. I think you would then do an analysis where you look to see if there was probable cause in the first place without the anticipatory portion, because probable cause is the standard that protects the citizens from the unwarranted search and seizure. So if probable cause existed, then there was no constitutional violation of the defendant's rights and thus no basis to suppress the evidence that was obtained. I understand the concern about the magistrate said that this is what you needed to do, but I think in the final analysis, the most important focus is, was there probable cause? And if there was probable cause, regardless of any police misconduct in obtaining the warrant in terms of, say, a Frank's hearing, or things didn't work out as they anticipated, the anticipatory triggering events didn't occur, and they executed anyway, the defendant's, as a citizen, his rights are equally protected if there was probable cause to search the property at question.
But is it a search pursuant to a warrant if a condition of the warrant is not satisfied? That is, don't do it until this happens.
It would, but if they jump the gun, so to speak, and do it prior to the occurrence of the conditions and probable cause existed, then the Commonwealth's position would be that the triggering events requested were unnecessary and they can be excised out, and the analysis would remain the same looking at the four corners of the search warrant affidavit.
But you would still be viewing it as a search pursuant to warrant as opposed to a warrantless search at that point?
Yes, because there was a warrant and you would analyze the probable cause within the search warrant outside of the anticipatory
It would have, yeah,
triggers.
it would have to exist in the four corners of the warrant.
Exactly. And if probable cause existed in the four corners, then the defendant's, or the target of the search is his constitutional right to be free of unreasonable search and seizure has been protected.
Did the police have probable cause without inserting the anticipatory conditions? Did they know enough to get a warrant without resorting to anticipatory events?
Yes, that would actually be the Commonwealth's initial argument, was that within the four corners, without them requesting it as an anticipatory warrant, they had sufficient probable cause.
But they chose not to go that
They
route.
chose not to go that way. It's speculative, but from the reading of the warrant, I would suggest that on the date they requested the warrant, they did receive further information. This was clearly an ongoing investigation with this confidential source, and the source said that this is going to happen as well. And so at that point, I would suggest, out of an abundance of caution, they included that language about what they anticipated would happen, that the defendant, that Carlos, the nephew, would take certain steps, and that's information that they received from the confidential source, who had been very reliable and had a basis of knowledge in the past, and included that in, and out of an abundance of caution, requested it as an anticipatory
Could
warrant.
I just clarify? I think you have, but just to make sure, because I wasn't sure what you just said. Do you take out all that was anticipatory, or do you elect which in the chain of anticipatory events you can stop at? So is it only what they knew at that point, have what they themselves observed, Or do you add, well, then we are going to see him go there and then leave, but we're going to stop as soon as he leaves? Can you do that, or do you have to take the whole thing out?
Well, I would suggest that that the court would take it in where there's this sort of a challenge, where it would take it in steps. First, look at the four corners without the anticipatory. If there's enough there,
Without the whole, that's what
without
you're
the
saying.
whole thing, if
So
there's
you're saying
probable
there's
cause
enough for-
there, an anticipatory warrant was never necessary. Because an anticipatory warrant contemplates there not being sufficient probable cause in what had already happened.
I thought you were saying it was okay that he left, and they could
No,
stop there.
no,
All right.
no, I'm saying
Thank
that
you.
if you look at the four corners and there was not sufficient, then look and step by step. And to determine whether or not at any point in that chain there was probable cause to justify the search under the Fourth Amendment and the Declaration of Rights, Article 14. And if, though there is probable cause at any point in that chain, the defendant's rights to be free of search without probable cause was not violated.
Let me ask you this question. I'm assuming that the search of Carlos was done pursuant to an arrest, not pursuant to this warrant.
I would assume the same, Your Honor.
Right, because he was not in the apartment. The warrant authorizes searching people in the apartment.
Yes,
But not
yes.
others. Okay.
Yes, he was
So
searched.
they basically stopped him.
Yes.
Had probable cause to arrest him, discovered that he indeed had the cocaine as
Yes.
predicted,
Yes,
having just left the apartment,
precisely.
and then chose, as opposed to waiting for him to deliver it to this person in the South End, they intercepted him in the delivery, and that proceeded to lead to the search.
Yes.
Am I correct that you have essentially two separate and independent arguments? One is what I'll call the Franks argument, which does not require substantial compliance with the anticipatory condition, and then a second argument that says there was substantial compliance with the condition.
Yes, it's that, my initial argument was that there's sufficient probable cause under the warrant without any anticipatory portion. Then.
And that it doesn't matter even if the police were to blow off that condition entirely.
Yes, because there was probable
Okay,
cause,
I
and
get that.
if there was
but
probable cause.
But I hear a second argument that says there indeed was substantial compliance
Well,
here.
if this court were to find that there was not sufficient probable cause and that the anticipatory warrant was necessary to create the probable cause to justify the search, then at that point, the compliance with all of the triggering events that directly tied the illegal narcotics to the targeted apartment of the search were complied with, and that would be also, and that they then created the probable cause that allowed for the
And
search.
if there were, if substantial compliance were to matter, would there not be a need for an evidentiary hearing to decide whether there was substantial compliance? Because this was, I guess, a four corners, this was purely looking at the affidavit.
It was four corners with a kind of a four corners plus. There was discussion on the record as to what occurred, but it wasn't in depth. There was discussion amongst the attorneys in their
Right, but there was
filings.
no
but there was
evidentiary.
No, there was no evidentiary hearing, and there was no conflict
is it-
between the parties. They all
I'm gonna say,
agreed as to what
was it
happened.
disputed that
No, it
the arrest
wasn't-
was made after he left the apartment, when he got in the car, at the
Right.
at the time that the confidential informant said he would?
Precisely.
disputed,
There was
was
no
it?
dispute into what happened at the time of the execution of the warrant, and that Carlos did not comply with the last event in the chain.
The police didn't wait
And
until
that
there
was what
a
the
delivery.
challenge was. The defendant tied his challenge to the execution of the search warrant to the failure of the delivery of the narcotics.
All right, thank you.
Thank you very much.
We'll take our morning break.